Two Filipinas seeking permanent resident status in Hong Kong lost their appeal before the Court of Final Appeals. The unanimous ruling of the Hong Kong Appellate Court favored the government's stand that domestic helpers don't have the same status as other foreign residents who can apply to settle permanently after 7 years. Many of our countrymen have been working in Hong Kong for so long, and they believe they have the same right as other foreign nationals. And joining us tonight on Newslife is Attorney Hans Cacdac, the Director of the Philippine Overseas Employment Agency. Good evening, sir.
Good evening, Mark, and to your televiewers. Good evening.
Sir, there's Robert. Sir, just to start us off, Evangeline Vallejos and Daniel Domingo championed the rights of not just Filipinos in this case. Both lived and worked in Hong Kong since the mid-80s. Is there any remedy for the two?
Well, I'm sure they have been advised by their lawyers about their recourse. I know this is a high court decision, so there may no longer be any remedy by way of appeal. But again, I would leave this to the lawyers in Hong Kong as they would be more familiar with the procedure.
Sir, what is the POEA's position on this, and can their case be appealed outside of Hong Kong?
Well, this is a advocacy and a legal move by the Filipino workers, the two Filipino workers in Hong Kong. So the Philippine government technically was not a participant in the proceedings. So once again, I leave this matter to the petitioning Filipino workers in this case.
So what is POEA doing in coordination with DFA and also with those who are working abroad to help them in times like these?
Well, what we do at the POEA is coordination with our Philippine Overseas Labor Office to keep us posted. This is a case filed before a foreign court, and so the court in a foreign jurisdiction had decided accordingly. So what the best that we could do is coordinate for information purposes with their Philippine Overseas Labor Office and try to assist overseas Filipino workers the best way we can in terms of their welfare as well as their protection as workers in Hong Kong.
Sir, as we see it, year on year, we have many OFWs leaving the Philippines to work abroad, and a lot of them also are domestic helpers. Looking at the bigger picture, if other foreign nationals are granted residency, why not domestic helpers, and how different are their rights?
Well, domestic workers in Hong Kong, as far as the POEA is concerned, are afforded certain protections with regard to what we call the household service workers package, meaning they have a minimum salary of $400 and a minimum age requirement and a minimum training requirement, as well as protection from placement fees with the no placement fee rule. So these are the protections afforded from the POEA side. And as for the status of our domestic workers in terms of the residency requirement, again, this is a particular rule under a particular system under another foreign jurisdiction. So the best we could do is coordinate with our labor attaché in Hong Kong, who will keep us informed about the developments of the case.
So this seems to be a test case. How is the decision, and will this mean that employment of domestic helpers will now be limited for a specific time frame?
Well, as I understand it, the case involves a residency requirement and how domestic workers are not covered by the residency requirement. So this is a law of a particular rule in a particular foreign jurisdiction that we at the POEA have no direct control over. So the best that we could do from the POEA side is to guarantee protection of our overseas workers in terms of their employment relations with their respective employer households.
Sir, in the meantime, will you stop the deployment of domestic helpers to Hong Kong? And how many are working there right now?
Well, on a yearly basis, we have around 25 to 30,000 deployments of domestic workers or overseas Filipino workers to Hong Kong. And of course, this particular decision will have no bearing in terms of the deployment status and the continuing deployment of overseas Filipino workers in Hong Kong.
Sir, just looking at this, how significant are the remittances? And if you're a professional and worked and lived there for 7 years, you can be granted residency. Am I right, sir?
Well, that is for the other skill sets, as I understand it. Again, I would leave the response to that question to the legal experts in Hong Kong, because I think precisely this case was all about seeking residency for domestic workers in Hong Kong.
But sir, wouldn't it be the case if professionals are allowed residency after 7 years? Would this now be a case of discrimination? And what can the government do?
Well, insofar as the POEA, again, we will coordinate with our labor attaché. I'm not in a position at this moment to comment on whether this constitutes discrimination or not, but we will coordinate with our labor attaché and provide any assistance possible to the Filipino workers who were involved in this particular case.
Sir, for domestic helpers who go through the POEA to try and get jobs, that's not only in Hong Kong but in other countries, is there an orientation for them so they know what their rights are when they arrive at their destination?
Yes, there's a so-called pre-departure orientation seminar that the Philippine recruiters are supposed to provide to the domestic workers so that they may know what their rights are from the Philippine and the Hong Kong perspective. And also there's a language and training seminar that is provided by the Workers' Welfare Administration, and that is on top of the regular national certification training requirement from a TESDA accredited institution.
And so finally, are they also told that when they enter another country, their rights are probably different than that of a professional?
Well, what we strive for, based on the Philippine perspective, is the advocacy that domestic workers perform work just like any other ordinary worker, that domestic workers have rights that are human rights. And so domestic workers should be afforded just as any type of human or employment right, just as similar to any human right or employment right that is afforded to any worker.
Okay, on that note, thank you very much for joining us tonight. That was Attorney Hans Cacdac, Director of the POEA. Thank you, sir.
Thank you.